Odofo mesanso ema mu nyina akwa aba e de ba Ghanatube odofo breaking news kesiye e na asan abeto Ghanatube amedi ni nyina bro odofo munin se eye Ken Ofori-Atta or the OSP eko eye court sisi amena okasa no Accra High Court at the final ruling concerning Ken Ofori-Atta at the Aba. Ken Ofori-Atta ni case no the court Accra High Court no. Sisi amena okasa no judge kesiya otina court hono e Accra High Court no wa bo Ken Ofori-Atta na senu nya atu egu. Just a case na Ken Ofori-Atta the court Accra High Court editia OSP say sa warrant na ode ato no so no Accra High Court omun kebima no mu yimfe ne so no Accra High Court dabida sa warrant no abekoso ada wo so saa ntisi amena okasa no Accra High Court o must strike out Ken Ofori-Atta ni case no ode call ohono mu concerning ne warrant case no ntisi ano Ken Ofori-Atta still ano ne ho ache dendenden ne warrant na da ne so no de still an egusu de hwe no Accra High Court aboni nsem nyina atu egorofo mama enko ne enko tie sansem nyina nchirem e wo Ghanatube na mraisia
to court, because I mentioned there's been quite a number of developments there where the High Court, that's the criminal division, has dismissed an application by former Finance Minister Kenneth Ofori-Atta seeking to strike out a warrant as issued for his arrest by the Office of the Special Prosecutor. Mr. Ofori-Atta had argued that the OSP unlawfully obtained the warrant and asked the court to set aside all related proceedings, including an Interpol red notice alert. However, the court this morning ruled that the application lacked merit and dismissed it in its entirety. And if you'd recall, the Office of the Special Prosecutor somewhere earlier this year issued that Interpol red notice alert for the arrest of Ken Ofori-Atta somewhere in March. The OSP subsequently withdrew that red notice, but it didn't stop Ken Ofori-Atta and his lawyers from proceeding to court, asking that the court bars the Office of the Special Prosecutor from, in the future, putting his name on red notice amongst many other things. But the court has outrightly dismissed that. We know that the OSP has put Mr. Ofori-Atta back on a wanted list. There's an Interpol red list as well, and there are efforts underway for his extradition to the state over some investigations currently ongoing with respect to his time as finance minister under the Akufo-Addo administration. But we're staying on the subject matter of the courts, where we're taking you there right now. On that first story we brought you about the High Court, the Human Rights Division striking out the Chief Justice, the suspended Chief Justice's judicial review request. 6 Don Ulo is my colleague in court for us. Let's connect with him for a bit more details on the argument and the justification that has been coming from the court. 6, talk to us. She was seeking, amongst many other things, the court to affirm that her rights were being abused by the Article 146 committee. Walk us through what the argument of the court was in dismissing her judicial review.
You are right to have put it the way you put it. And the court said that if you go through the arguments that have been put up by the Attorney General and lawyers for the Chief Justice, it cannot be said that the Chief Justice is using the court for its right purposes. And the court is particularly concerned that the issues that came before it are not matters that are within its jurisdiction. You recall some of the key arguments that the Chief Justice made, both before the court and at a press conference where he openly voiced some of the misgivings about the committee and its operation. For instance, you recall that he spoke about the way he was subjected to bodily sex, which bodily sex he described at the time as being delayed, and he said that it was not something that should have been condoned, and he thought it wasn't proper, even given the weight of the office as Chief Justice of the Republic. And so he thought that it was not right. You also recall he made the argument about not being availed.
Order 4, Ken Ofori-Atta and an watching ye papa. Mom in saw the case or court. say Accra High Court and as a court nankasa nkebi mano because our warrant kese ne dey ato ne so ne dey odwen ho tiase disi a Interpol America US nyina ye hye no Interpol they say ni din that red list ne so and disi a no bi Ofori-Atta enam bia ne the satellite is in so because hye na action e o Ghana hase rofo enti ni Ofori-Atta ne lawyers omo the same way at the call high court and omo the court say court no interpret is as we nyina bi emo no mu yi sa warrant mfini so but say me no kasa no Accra High Court say da bi da on pene so warrant na da na so say hye na action no di eno na be da na so disi ano Accra High Court o ma dismiss sa case no disi a me no kasa no sa warrant case na e da na so say hye na action no nyina still go so da na so as a wanted person Interpol omo red list ni say omo red list ni nyina no ye de na kan ho agisi ano America fo nyina no ye de satellite atu Ofori-Atta so a ye hwehwe na achi ne dendenden idisi ano ameno kasa tintontan Accra High Court no was striking out the case no it is still ano Ofori-Atta no still ano or wanted e o baby adofo when ensem ayekoso concerning Ofori-Atta any suspended Chief Justice on also the updater Mr. nyina brel e Ghanatube manko na entu asomra di cia e Ghanatube so
authenticated copies of the petitions as had been presented to the presidency against her. Her argument has always been that for my removal, that petition has to be received by the presidency and that transmitted to me, the person who the complaint is against, so that I can adequately respond to it. But as we mentioned in all of the press conferences and the submissions that we have made also before the court,
right.
we said that we were not granted those topics.
Sixers, right, Sixers, if you could kindly reposition, there's a bit of a difficulty in being able to hear your submission as clearly as possible or possibly position.
Fibolence. Partially hydrolyzed gargum. Fibolence is a novel brand of
the CJ's counts one after the other, not her counts, but her relief she was seeking for via that review. Continue for us. Hopefully we can hear you a bit clearer now. Hello, Sixers.
Hi, Madam.
Yes. Yes, I was saying that we were struggling to hear you quite clearly. If you could just reposition, even if it's the direction of the phone, so that we can hear your submission a lot better. But you were walking us through the reliefs the CJ was seeking via this judicial review. She, amongst many other things, said her rights were being abused. Her family and the likes were not given access to the committee hearing, the manner in which she was being searched, amongst many other things. You were explaining the reason of the High Court.
Yes, and so based on those submissions that have been made by the chief justice, publicly and
well, it does appear there's a bit of a difficulty in being able to clearly hear the Chief Justice in her submission, but we were hoping to speak to private legal practitioner Martin Pebu. He is thankfully joined us on the telephone line right now. Hopefully his connection is better. Counsel, I appreciate you speaking to us. That's the verdict of the court, dismissing outrightly the review as being sought by the Chief Justice. They make an interesting argument that the matters in which she is brought before the High Court, amongst many other things, is pending before another court. Is that justifiable enough reason to have dismissed the case, considering there's a school of thought that you can be seeking an appeal of a decision whilst you also apply for a judicial review?
Great. Yes. You can be appealing a decision and also applying for judicial review. That's correct. It's a legal principle that's well known to lawyers. Okay? Yes. But in this particular case, what you find is that what the court, from the report that you give, it says the court says an abuse and they have no jurisdiction. Now, if we say she's appealing, I'm not altogether clear where she's appealing, because the matters that were before the Supreme Court, yes, the substantive matters are pending. So maybe the other way to put it is that some of these matters are indirectly pending. You know, she has the ECOWAS court case.
Right.
But that one is outside Ghana.
Of the country's jurisdiction.
So, but you know, the High Court usually, that's how come usually will be safer to see the detailed reasons of the court. So that if the court meant the ECOWAS court, okay, then that means that the Ghanaian courts take the decision that if you go to ECOWAS, they will listen.
Right.
But you know, for the ECOWAS court, they have the principle that if your case is pending in the domestic court, you can still come to them and they will listen.
Yes.
But if our Ghanaian court is saying no for them, if you go to ECOWAS, don't come here, okay, that means that we are shaping a different jurisprudence for our internal consumption. Okay, so let's get the detailed reasons and then see that is really within.
Right.
Because you see, yeah, go ahead.
No, I'm listening to you. Perhaps you make that point, then I'll come in.
Okay. Yes, because you see, our courts, yes, want to maximize the use of resources. You know, we don't have much resources to go around. So if the court finds that, look, these matters you are complaining about, they are also before the ECOWAS court, and so the court doesn't have any appetite to deal with it, fine. But the court also makes the case that there is no jurisdiction at all. That is the one that we have to explore to see. Meaning that the court says that all issues like this should deal with the Supreme Court. So like I said, that's new learning. Because ordinarily, a lot of us thought that the High Court can go into these matters. But if the court takes the decision that takes the view that no, once it's Article 146 for them, it should be the Supreme Court, what will happen is that then this area has to be developed. So Justice Tokono has a right to go on appeal. Let's see if she will take that decision. Then the law around this area will be properly developed.
Right.
You know, we don't have many cases around this area. So it's difficult to stick out one's neck and say the court is right or wrong. Because for a lot of us, we thought that, yes, she could go to the High Court. But the High Court says there's no jurisdiction, then let's see what an appeal will do. And then finally, a further appeal to the Supreme Court.
It's important you make that point, because the next question I was going to ask is whether or not the grounds for a judicial review are not entirely different from what the substantive case is before the Supreme Court, where they are seeking to enforce possible provisions of the Constitution or interpret provisions of the Constitution. So what you're saying is, these are uncharted waters again for us, which possibly we all as a country have to be doing some new learning on.
Absolutely. Your summary is very informed. Yeah, it means you really understand the case. Yes, that's all that I was trying to say. Yes, very good.
Right then, Counsel, I'm sure we'll get the reason ruling, and then we can come back to you again for a bit more. I appreciate you speaking to us as always. That's private legal practitioner Martin Pebu speaking to us this afternoon. On the latest, the High Court, the Human Rights Division, they've struck out the CJ's request for a judicial review over the ongoing processes of that Article 146 committee in looking into prima facie determination seeking her removal. But we can take it to Parliament now.
The House has approved a request.
Order for when they ain't some I did judge say. Can Ofori-Atta name some na see ya bo atuegu e Accra High Court. See ano warrant na ye hwehwe no nationwide and as international level say warrant kese dan so Interpol na adi nyina no still ano egusu won so because ye hwehwe na achi no case no de ko Accra High Court no see na Accra High Court no abos asem nyina tu egu nti see ame no kasa no still ano Ofori-Atta or ye wanted ye hwehwe na achi no and now when you suspended Chief Justice nso no na asem na odoko dan court no ono so ya bo na asem na to you see a lack jurisdiction and now when you say abuse of the court processes sisi ana mena okasinesi say un say high court e di wasem na sanko yi a ye hwe enim say eye suspended Chief Justice no obekuku case no esanso dia ko appeals court odofo odebekọ appeals court and aso fanko we asem sebe odofo mamuru efisamba like no ma subscribe no ma share no ma hit notification bell no so am say be ya abrini abibia drop consent say ya wo nya ntempa no ahwe no ti odofo aha na me de nsem nyina besi e Ghana tube so makra mu nyina eda mu nyina say